Welcome back to the business, and we're on the last legs now. This is number 4. Hopefully we're not going to be in this area for long. We don't like this. It's the legal route. We've tried everything now, Nigel. We can't get paid. We've tried chasing the debt ourselves. We've tried using someone like yourselves to chase it. We've done the arbitration, the mediation, etc., etc. They're just not going to pay. What can we do now?
You have limited options. Ultimately, you have to go down the legal route. And this all depends on the size of the debt. Now, I must stress that this is the size of the debt before you add any charges on. So before you add on legal charges, so if you're a commercial company, if you're an actual limited company, then you're allowed under the Late Payment of Commercial Debts, in brackets Interest, close brackets, Act, 1999, and that particular act will means that you can add interest and charges on. Those charges are laid down in many government websites. They're straightforward, and you can also add interest at 8% over a base rate. Now, you've got to be careful about the base rate. Whilst it's been quite stable at the moment, therefore 8% above 0.5% is 8.5% per annum that you'll be able to charge. But these interest rates only get charged once every 6 months, get changed once every 6 months. So be careful that you don't think automatically the Bank of England puts their rate up, that you can charge immediately. You can't. It depends when it's next put up.
So how much do you need to owe then to go through that route?
Well, if you go through the legal route, you can owe anything. I mean, it can be any amount from £1 up to £1 million or beyond. Obviously, you've got to be sensible about it. How much are you willing to pay to get back a certain amount of money? I would suggest that if you owe anything under £50, it's unlikely it's going to be financially viable for you to try to chase it through the courts. The smallest amount of fee that you can do, even if you do a county court judgment online, will be £30.
Right.
And then you've got ancillary costs beyond that. I will stress right at the beginning of this that getting a county court judgment against someone, getting the judge to say yes, you are valid, you have a valid debt, doesn't mean you've got paid. It just means you've got a judgment.
Yeah, because you hear so many people where they say, well, I took him to court, I got my county court judgment, and it's like, right, what happens now then? I didn't get any money. So
Absolutely.
What happens there then?
Well, you then come and see someone, either a solicitor or someone like ourselves, and we will give you the options that you have available to you. And you have various options. You can, for instance, ask the courts for a warrant of execution. And a warrant of execution for amounts less than around about £5,000 will be done by bailiffs. Now, bailiffs, and if there are any bailiffs watching this, I apologise, but bailiffs aren't the brightest people around, neither are they as successful as you would think. They have no legal right, for instance, when they enter your home, to actually sequestrate your goods immediately. All they can say is, are those goods yours? Now, your average serial debtor is going to say no. and they can't argue. So that's the end of it. So they'll come back saying, well, there are no goods to distrain, so, and that's the end of it. And that's a little unfortunate. If it's above £5,000, you can actually have a person called the High Court Sheriff. Now, he's a different kettle of fish. He can actually go and sequestrate your goods. So he will go across there and he'll say, is this big flat screen TV yours? And we'll say no. So right there, well, there's a sticker on it saying it's mine. Now prove it isn't.
Now, yeah, see, I like that way. That way, I like that.
Absolutely.
You know, from someone who over the years has had people go bust on me or not paying. I like that, because that now they're going to have to try and prove that it isn't theirs.
Absolutely. Yeah.
Yeah. So that will work quite a lot then, Nigel.
It will, and it works quite well. The difficulty sometimes is knowing whether or not your debtor has any funds or any assets in order for you to go and look for. And sometimes they'll say, no, I've got nothing. And you say, well, I'm sure they have. But you've got to be sure before you take any action. So you can go for an order. And it's a special order. It's called an order to obtain information. It used to be called an oral examination. And effectively what happens is a judge, and you're best to find a judge to do this, a district judge, will have you in chambers, yourself as a debtor, the creditor, and they'll be requested to go. And if they don't turn up, there are major penalties for them. And under oath, they have to then discuss their liabilities and their assets. Usually they take an accountant with them to try to explain those. If they lie, they're potentially looking at a prison sentence. So this is not now going back to just, oh, well, I've got a few £1,000s owing. This is going to something serious. So these people better make sure that they don't lie to the judge.
Wow. That's a long time coming. If I supplied somebody some goods, let's say on January the 1st, and I put all the processes in place at the right time, how long do you think it would be on, let's say, if it became due on January the 1st, how long does it take to get to that position where you're with the judge in the chambers? How long does that normally take?
Well, strictly speaking, you could have that done within the month. However, no court would be comfortable with that happening because people generally do pay a bit beyond the credit terms nowadays. Under normal circumstances, if you went through a full 90 days of collection procedures, followed by maybe a further 30 to 60 days of going down an independent debt management company trying to recover that, and finally going down the county court route, 6 months from start to finish. It's a long time, I know, but better to have a file and better to do it systematically than try to go there quickly and find you've missed something.
Yeah, I mean, advice you're giving is correct and great, but a lot of the businesses that are watching this is like, oh, 6 months, I need my money now.
Sure.
It's like there's no quick cut to doing it then.
There is, as I said, if you decide that someone's gone beyond their credit terms and you have exhausted your procedures, now these procedures have to take a certain amount of time. So if you're giving them 30 days credit and you've given them a further, let's say, 60 days, then strictly speaking you can go straight to court. There is no argument with that.
Yeah.
You've given them enough time, you've gone through the process, but bear in mind that the judge will want to see that you have asked this person for the money, that you've gone through a process to ask that money, and that these people have actually come back to you and said, well, I can't pay, or there's an issue. What you usually find is someone will not pay, they'll ignore you, or they'll just not pay for a period of 30, 60, 90 days, and then right at the end, when you're just about to take them to court, they'll say, actually, there was a problem with the goods. So you have to go through this issue. Bear in mind, you can't take someone to court, a straightforward county court judgment, if they have a dispute on that debt. If the debt is disputed, then it can't go down that route.
Right. Let's say that we've got them to court. They owe me £5,000 or whatever, and the court says, right, you can pay £50 a month. They've really got one over on me there, aren't they, really? Because £50 a month is like nothing. It's not helping me with £5,000, is it?
Well, again, the easiest way for you to do is if you believe they can pay more, and sometimes they can't, despite what you think, but if you believe they can pay more, then go for an order to obtain information. And find out what their assets and liabilities are. And if they can pay more, then you can go back.
So if it was found out if they've got more money, how do we do that then?
You go to the court and you ask for an order to obtain information. And the court will then give you a date in which preferably a district judge. The reason I say preferably is they used to be done by a court clerk. To be fair to court clerks, they struggle to get the right information. You sit in front of a district judge under affidavit conditions, when you're under oath, with a prison sentence hanging over you if you lie, and amazingly enough, people tell the truth and they'll tell you what the assets and liabilities are. And if they have more assets than you thought, or that they'd originally disclosed to the court, then the judge will then rule that they pay more money, maybe even pay instantly to you. There is a sidebar to that as well. If you find that they have a substantial asset, such as a house, then why not go for a charging order on that house? Now, it might not get your money back immediately, but if you do a charging order on a substantial piece of property, and it has to be a fixed asset, such as a house, they can't sell that house until they have your permission to go through with that, and they have to pay you if they do go. So the solicitor, when he's actually divvying up the proceeds of that sale, will have to pay you first, in the same way that they would have to pay a legal mortgage to a building society.
Wow, well, we've covered quite a lot there, Nigel. I'd like to thank you for coming in today, because a lot of the stuff you've said there will be invaluable to a lot of our viewers. So thanks for coming in.
Yes,
now, Nigel's got a profile on the site, so if you do need any help, click on his profile, contact him and get him on board. I'd like to just finish the 4 videos with a little bit of advice from me that hopefully will help you. First of all, before you even deal with anyone, may I suggest that you do a credit check on them. You can do that through our site with a simple text service. Ask around, who they're dealing with at the moment. Are they getting paid on time? Get a little bit of background about who you're dealing with. As I've said many times in the videos, an order's not an order until it's paid for. And lastly, it's great using people like Nigel, very useful. I used to use people like him, as I've said before myself. However, when it goes beyond that, you've really got to sit down and evaluate where you're going, because the amount of time, effort and worry that you put into chasing that debt can be better served getting more sales in from people that can pay. Keep your focus on the business, on the good things of the business, not the bad. We don't need them, we need the good. So keep your head down and keep going for it. Thanks for listening to the videos. Hope you enjoyed it. It's been great with Nigel. Thanks again.
Thank you.